Thank you, Betsy. Greatly appreciate it. Let's do this more of a workshop approach. So if you have questions along the way, I really don't like it when someone says, hold your questions till the end. Because if I confuse you in the beginning, you'll be confused at the end. So let's make sure we're all in the same boat and make sure that we're all understanding what's going on. Just a few items here. Basically, this is my workbook. I see people handing them out. I greatly appreciate that. Make sure you have one. One for a couple is fine, typically. Inside my workbook are a number of items. We'll refer to the workbook in a second. I do have a hello. If you want to take advantage of a free consultation, I'm not pushing it. I won't make this educational, but it's there just in case for you. One of the things we like to tell clients about is to let them know that how do you communicate with the family post your death. And a lot of times we do it outside of the trust. We do a special letter of instructions. One of the things about the special letter of instructions, it talks about who to contact if you pass away. Also, where you hide things. That's, when someone dies, it's like a treasure hunt. And some people leave better maps than others. So this is one of the things. The other thing also, when it comes to personal effects, we're not talking about wills and trusts just quite yet. But, you don't really want to put small stuff into the trust. You really, you might have a little note to your trustee, please give my wedding ring to my daughter, my hammer and jigsaw puzzle, whatever, or to my son or whatever. So basically you can do that. We just added a new page in last year because we're having a lot of clients that have pets. And actually we decided they need to go somewhere. So sometimes my clients' pets are more important than their children. And basically they want to make sure they go to good homes these days. Another thing is that we have what's called, and you say, Arthur, you picked the right color. This is a lovely pink. This is called a post form. A physician order for life-saving treatment. This is not my color of choice. When you go to the hospitals, it used to be, they could recognize this, everything's digital these days, but it used to be that they know this has to do with your wishes as to what happens at death, towards the end of death, towards life, excuse me. And we'll talk about this later on as well. And too many times, people miss the long game. They're missing as to what happens at death. When someone dies, actually, when the first appointments, I have a checklist, and we go through it. This is actually my one-page checklist, but I have a multiple page. So here's some ideas what you need to do. Start off, someone dies, take care of your loved ones. Get the death certificates. We'll need that for affidavits to clear out title. A whole bunch of things you got to do, and this is some of that we'll go into. This is not the main focus. Let's back up a little bit. When I first saw proxy law back about in 1986, people used to say to me, if I die. Well, people are pretty smart. They recognize today it's not if I die, it's when I die, but if I become incapacitated. And so basically we're going to talk about planning. We're planning not only for death, but also life's issues. What happens if you become incapacitated? We'll be addressing this in a second. So basically, I've been an attorney since 1986. I really basically have done nothing but estate planning. And I was working for the DA's office. Oddly enough, I started up in Los Angeles at Torrance and Sherman Oaks, and I came down here and worked for a lawyer actually across the street here, and I eventually went to the office next door. So it's kind of memories. I know exactly where you were, Betsy, tonight. So I've been a certified specialist since 1993. You have to get recertified every 5 years. I've been basically, I've always done it. I'm a estate planning attorney for life, not only planning for death. We'll talk about what that means a little bit later on. And we do full services. I know some lawyers out there, all they do is just the creation of a document. They don't really implement them. Do they really know where they work or not? Basically, we do a lot of helping clients as to doing things. And basically, it's not only what happens at death, but during lifetime if we need to do things. I would estimate over my 30-plus years, I would say we've done over 6,000 estate plans. My wife, Rebecca, she just retired last year. I had to change my slide. And basically, she retired from as a certified nurse midwife. She is actually delivering babies. What do? I deal with people, towards the end of life. So we have a big span there. But to get you the big picture is my mother was a wedding coordinator and my dad was a divorce lawyer. So we cover ourselves pretty well, I think. My son just graduated from SMU in Dallas, Texas. He's looking for a job. Anybody have jobs? Let me know. No, he's actually wants to go to New York. He's actually, oddly enough, in the Maldives Island. Anybody know where the Maldives are? A few of you do. 13 time zones ahead. But he comes back Monday. He has 2 Mondays on Monday to fly back, so it's kind of interesting. Anyway, so he's going to be looking for a job soon. Anyway, so what is my practice all about? It is more than just creating a will or trust. Basically, we do estate planning, based in advanced planning. We'll talk about that. Trust administrations. What happens at your death? What happens if you become incapacitated? We do a lot of live trust administrations. Probate's the other end. If you don't do things to avoid it, you have to do probates. We have more probates going on right now, oddly enough, and they're large probates. We had a number of clients who had children who meant to come see me. Unfortunately, the child died pretty young. And interesting enough, I was talking about cancellations, and basically we had a client who had probate we're doing for right now, actually had last year, was supposed to see me 3 times, and he kept postponing it. Well, procrastination, we'll talk about that later on as well. Blended families. This is the time, you have a husband, you got a wife, they each have kids, and they have their joint assets. It's one of those things we got to analyze and make sure that it's right. There's a term called elder law. I'm a psychology major. I actually like what I do. I deal with a lot of clients. Once again, we deal with more than just death planning. What happens if you become incapacitated? We'll talk about that. Part of that is actually what's called Medi-Cal planning or VA planning. I'm VA certified. I can't even talk about it unless I'm certified. So I have a number of clients. The rules keep changing, and there's a major rule today that really changed that I was talking to a client. It says, how much in assets do you need to qualify for Medi-Cal? And a Medi-Cal is what we call in California, we like to be unique. Outside of California, we call Medicaid. They're going back to Boston. I said, well, I don't know about Boston, but in California, the law just changed this year. We don't look at assets anymore. You could have $100 million worth of assets. Technically speaking, you could qualify for Medi-Cal. Back east, a single person is only $2,000, but of non-exempt assets. But they look at income now as towards share of costs. But I don't know where we're going to go with this one. This is a brand new law, and I don't like what I'm hearing about so far. Anyway, charitable gifting. We're actually going to talk about tax planning. When you pass an asset. Most of the time, especially I think some of you are probably going to be long-term investors. Maybe it makes more sense to pass it at death because to avoid the appreciation and avoid the capital gains. So basically, we'll talk about that as well. In my office, I have myself, obviously. I have a long-time associate, Catherine Kaufman, who's been with me about 18 years. I have Ruby, who actually lives around the corner here, so you might see her as well. And then I have Rachel. Fundamentals of estate planning. What do we need to do? We're talking about estate planning. People call me all the time. I need a trust, or I want to talk about a trust. You need to talk about more than just that. There is more to an estate plan. But then we'll talk about the challenges later on. So who needs an estate plan? I'll be honest with you, all of us does over 18. So basically, why? Because we're an adult. Within about 6 months of my son turning 18, one of the first things that my wife and I did, actually, we lost control of overlooking him. So we did a financial power attorney. Not we, I should take that back. I did the financial power attorney. My wife's in the healthcare field. I did a healthcare power attorney for her to be able to speak for him. We're all individual. And just because you might be married doesn't mean that your spouse can speak for each other. So you need to do some planning on that. I think also that if you have any kind of significant assets, my son does not have significant assets. I'm not doing a trust for him right now. I did a simple will. What should happen if he passed away before we intend him to do so? It needs to go somewhere. So we did a simple will. If you got real estate in California, I want to tell you right now, don't challenge me on it. You need a trust. Also, we haven't talked about probate yet, but if you have real estate outside of California, you need to have a trust to carry that as well. Why? You could have multiple probates. You got 4 pieces of property in 4 different states, you're going to have 4 different probates. How do you avoid that? We'll talk about that through the living trust. And if you got minor children, Betsy, at what age are kids able to be financially responsible for themselves? Not 18. Let's put it that way. The law says age of majority is 18. So in my document, if your money goes to a child outright, it may be held through a guardianship until age 18, but when they turn 18, say, thank you very much, that's my money. But in the way I do it for most of my clients, I have a minor's provision that says anybody under 25. But I'll tell you, a good handful of my clients say, no, 25 is still too young, let's go to 30 or 35. So it depends on the client and what they're trying to accomplish at that point. Okay, so I'm talking about estate planning. And I recently got some phone calls and said, oh, you're a real estate lawyer. No, I'm not. I do estate planning. They saw the word estate. So we're talking about that aspect. What is an estate? Well, it is everything you have accumulated during lifetime and at death. And I will say some of us are worth more at death because of life insurance. And so basically, what happens to that? And so we're going to talk about what the proper way of doing that is. So before we go to the more integral parts, let's talk about death taxes. And federal estate taxes is a death tax. Will there be one? Well, basically, this is a moving target. And basically, the reason I say it, we'll talk about this in a second, but it's moving because every year it changes. And unfortunately, in a couple of years from now, it's actually going to go down. So most people will not have to do pay death taxes. Now, I'm hearing people talk about buying real estate. And I'm hearing people talk about mortgages out there. When you get taxed, by the way, it's based upon not the gross value. The gross value is what the fair market value is. So we tax them it's on the net value. We subtract out the encumbrances. We talk about the mortgages. We get down to a net value. If you're doing annual gift giving, I want to talk about this as well. You are today able to pass $18,000 to anybody you want. If you're married, 2 times, $36,000. People ask me the question, will there be taxes? Where do I deduct that out of my, Fred, where do you deduct that on your income tax return? You made a gift. Nowhere, exactly. And so people, and by the way, when you receive it, where do we pay to income tax on that? No. I know you earned that gift from your parents, but that's not the earnings we're taxing right now. So when you get money, it can be really helpful. And so basically, I was talking to John earlier about how do we get this money so you can go out and buy a piece of property. And we were talking about, gifts and loans. We're seeing more and more clients helping their children out these days. And they can make an outright gift. And if the gift is over $18,000 or $36,000 if you're a couple, then you start invading your exemption amount. And we'll talk about what that is in a second. And so I like things simple. And if we can make a simple way of doing it, then a direct gift. We used to get really fancy. We do these loans. Here's $200,000. And you're going to pay me back. No, but wink, wink, wink. The problem with that is there's paperwork. You put deed of trust on your property. It's not really the smartest way of doing it. So these days, I prefer, most of my clients will just bite the bullet, use the exemption because their estate is below what they can pass, and it won't be a problem without taxes on that. But if you do that, go see your CPA. If you make a gift of $200,000 this year, it's due next April 15th. So you have to do a tax return at that point. So with that in mind, inside my workbook, I apologize, this is my last of my old workbook, but on page 6.
Is anything not in the workbook?
Some people came in a little bit later, but well.
John? Oh, dear, that's going to be awesome.
And one of the things that's not in my work, and I apologize, I just got through my annual review letter for my clients. I didn't send it out yet, but I was going to hope to get the draft in there for you, but they forgot to do it. I have some better numbers. So back in 2010, the amount you can pass without death taxes is $5 million. It was going up. And basically now it's currently, you can pass $13,610,000. Last year, you could pass $12,900,000. It changes. And come next year, we don't know what that's going to be. Come 2026, the law does revert back down to this $5 million with a COLA adjustment. And so, depending on what your state is, a lot of clients won't have a problem with this. If your state is $6-7 million right now, it gives me a little bit of a heartburn in a sense, like what do we do for planning purposes? Because if it's going to stay high, then we don't have to worry about it. But if it goes back down, what should we do? Now, one of the things I do recommend to clients on the first death, if you happen to die with a good sizable estate, I recommend people going back to their CPAs at the first death and actually do a 706 death tax return. There won't be any death taxes to pay, especially if everything goes to a surviving spouse, but you get to use your deceased spouse unused exemption called DeSucia. And that allows you. So we have just done a number of these for clients where a spouse died, and I'll be honest with you, there was a CPA referred them to me, and I said, when your husband died in Florida, did you do anything? No. This is about $8 million estate. I said, look, I don't know what's going to happen a few years down the road. Let's go ahead and do it. And they did it. And actually, she has not only her personal exemption, but her deceased spouse's exemption as well. So really, when someone passes away, you should really kind of tend to the professionals to see what needs to be done and what has to be done at that point.
Is that lifetime exemption?
That's what the movie target. That's his lifetime, yeah. So,
Talk about 5 million, and it's supposed to be numbers, that means you don't actually have to.
okay, so if you die today and you're at $5 million, no taxes. Exactly right. My concern is you have a $5 million estate today. Can you imagine what your estate's going to be, let's say, 3 or 4 years from now? It depends if you get the right investment, it becomes $8 million. And now it goes back to 7. Do you have a tax? Yes, you do at that point. If it stays high, then the answer is no. So the problem is you die today, you're fine. You die next year, you're fine. It's 2026. We do not know. Basically, when Trump signed this into law, you can only go out 10 years, and we're going to sunset comes out unless they change it. Will it happen? I will say that my understanding is that it's never gone down. So they need to do something. But right now, sometimes it's not happening a lot of. So this may be something that will factor them into wanting to make sure it continues over and continues and get higher exemptions. But right now, I said a lot of people at 13,610,000 times 2 definitely don't have a lot of tax problems out there. So what is estate planning? I want to back up a bit again. That's what I said. Estate planning is more than just planning for death. It's the creation of your wealth. A lot of you are just working right now and building your estates. It's growing. And most of my clients are like mom and pop kettle. They put money away, they put money away, they put it away. I don't have anything, I don't have anything. All of a sudden, they have a lot of money over a lifetime. And basically, at that time, they want to retire and preserve assets. And then ultimately, they pass away. But the problem is, as an estate planning attorney, I am finding myself more and more up here. We're helping our clients to do things to preserve it. I will say I can be proactive. When you see a lot of professionals, you see a lot of lawyers, typically it is something that happened. You had a car accident, you got a divorce, you're looking backwards. I can look forward. We can say, what happens if you die suddenly? What happens if you die over a period of time? We're having clients have dementia. I've had a few clients have lived over 10 years with advanced dementia. Not easy at that point. And then finally, we'll deal with the death taxes, which, once again, we're not seeing this problem like we used to years and years and years ago. So when you see a mortgage broker, when you see a realtor, when you see any professional, you want to base who, the what, and the why. You got goals and objectives. You want to try to accomplish something. What are you trying to do? Do you need a house? Let's go buy a house. You got income taxes? You want to take care of them at that point. How do you buy a house? Do we need a mortgage? So basically, we need to have a game plan. And what happens here is we have to figure out what happens post your death. Because if you don't have your own plan, there is a plan out there. We'll talk about that in a second. But who will receive your assets? What assets are they? Do you want one house to go to a certain person, want another house to go to another person, if you have multiple houses? When? The law says at age 18, you can get your assets. But we think that's too young. And so you could have them delayed to a later time period, 25, 30, whatever you want to do. But, if you don't trust that 18-year-old, he should not be the person stepping in as your fiduciary to look at you, say, here's how we're going to manage the assets. So we may want to look to siblings. About 20 years ago, I had a lot of clients that had young children, and they used their parents. 20 years later, guess what? The client's parents are passing away. The kids are over 18. They're very responsible people. We're changing estate plans to bump off the parents because they're not there anymore and put the son or daughter as a trustee at that point. So here's some of the things that we see as problems. It surprises me, and the numbers are out there that say that over 50%, if not greater, do not have an estate plan. And that really creates a lot of problems. I watch the news, I see these young people dying, some actors we kind of seem to know, and I don't know what they've done, but the point is you got to have something, because if you don't, then you're going to look at the courts, and that's what we want to avoid. Back in the 80s and 90s, we used to do what's called AB trusts, and we basically wanted to have these trusts so we could preserve a deceased spouse unused exemption. These days, we don't probably need to do that anymore. We tend not to do an AB trust. We may do an AC trust or a marital trust out there for blended families, but you don't really want to make a trust hold assets unless there's a good reason to do so at that point. And so the things we can do. One of the things I was talking to John, the mortgage person back here, I said, when you see real estate and you're trying to buy a house, how do you buy it? And how do you take title? Basically, we got to have it in the name of the trust. We'll talk about it later on. But it's not uncommon years and years ago that they went to a mortgage broker and the guy said, you got to take it out of the trust. Okay? If you take it out of the trust, what do you got to do later? Put it back in. So sometimes through escrow, they would put it back in, sometimes not. Part of my annual reviews is I want to make sure my clients' properties in the trust. And one of the things you can do, San Diego County is great in a sense. You can read the property tax bill. Go up the upper left-hand corner, it says legal owner. Now, I just had a client confess to me that she learned something because she saw her mother's trust there, but she didn't understand the word at all afterwards. Well, at all means basically with other people. And so she didn't realize the house was not in mom's trust alone, but it was in mom's and dad's trust. And they thought that was, it was interesting. So we had to clean up a few things on that as well. Another thing is that not all assets need to go into a trust. We'll talk about some of those things. Retirement dollars, I prefer going to a spouse. They can roll it into an IRA. And then I prefer to go to a child after that. Life insurance, I do want to go to a trust. Annuities, I prefer usually to people, not the trust, but we can as well. But someone you trust is no longer trusted. They die before you. They move out of the country. You might have the wrong trustee. You need to look at this stuff. I personally think everybody should analyze their own stuff every year on their own and see, and then basically at that point, every few years, maybe go see it with a professional at that point. But you got to make sure. Yes, Betsy.
Just a quick comment. So I would say in the last 2 years, probably, well, certainly in 2023, probably a third to half of the sales that I saw were actually sales because of the death in the family. And I would say out of that, a surprising number, like 2/3 were trusts and 1/3 were probate.
Yeah.
Like a really high amount were probate. So it's amazing how many people, and then comes the gnashing of teeth with those family members trying to figure out what mom wanted or dad wanted and how they're going to do this, and the siblings that don't agree or are out of state, and what ultimately ends up happening is that the value of that property goes down because it sits before they can finally get it on the market. So nobody wins. Like whatever that person had intended, none of that happened, which is really a shame because even if you wanted to not give it to any family and give it to a charity or something, there's choices, right? Anyway, just wanted to jump in and say it's a much higher percentage than you would imagine.
Yeah.
I was really surprised by it.
What's surprising is that with all this talk about doing a trust, why is it probate so busy? And the thing is, it's busy because people are not doing this stuff out there. Some are, and basically you're right there. And what happens when you open a probate, you're frozen, you can't do anything. You can't sell the property until you get somebody appointed. We'll talk about that. Okay, so you got to make sure and analyze, do you have the right person? And I will let you know right now, I am not a fan of co-trustees as a general rule. I don't mind spouses. Occasionally I'll make a son or daughter co-trustee. But when people say, I want to have my children, oh my God, I have a little bit of, it's not my nightmare, but I talked to one of my clients' children, and I did the original trust, but they had gone to another attorney for the trust administration. That daughter, I got a phone call a couple of days ago, lives in Rome. And I said, you don't want a trustee who's in Rome and here, because actually, to be technical, but that's a foreign trust, and it's going to be taxed a little bit different. I think they're using a residence here, but I'm sorry, you have to watch out for some things out there. You got to read your documents. And I will say, some of these lawyers are pretty guilty, because I don't like this. My trust for a husband and wife, maybe 22, 23, 4 pages. It's not uncommon. I've seen an 80-page one or 100-page one. They throw the kitchen sink. I hate when I see this stuff. And so they're not reading it because it's so intimidating. And I've seen some lawyers say, look, we're going to give you only the important pages to read. I go, I don't quite understand that at all. And then human nature, procrastination. I'll do it tomorrow. I'll do it mañana. I'll do it later. The problem is, we've seen laters happen because they just put it off to the point it's too late at that point. So what are the challenges? Guilty attorneys. But when I see clients, I'm doing the trust administrations, it's only one attorney. But when you get 2 attorneys, do you think things double? No, they quadruple. And so basically we have to do attorneys. If we do it right, that's what we're intending. We want to avoid this whole process of the court, because who wins when you go to court? It's not you, it's the attorneys again. Estate taxes problem is kind of going away for most people. It may come back for some as well. Another big issue right now, aging, long-term care. What happens if you need assistance? We're going to definitely talk about this. Family, look, I hope you talk to your siblings when your parents die. Now, not everybody gets along with everybody, and most of the time they do. And I would say most of my practice, people do a great job. They do speak to each other. I tend to be an open book. I like to share documents. I like sharing things in advance. When I started practicing law, when people denied they were going to die, they didn't want to tell their kids anything until they passed away. I see clients sharing this stuff now, which is a lot easier. So when the time comes, the kids are aware of what's going on. Okay, so what are some major life-changing factors? Death of a spouse, death of a beneficiary, death of your fiduciary or trustee, divorce, remarriage, increase or decrease in your wealth. I mean, once again, you had assets, you get some inheritance, it grows, it grows. You're accumulating things. Do you have the right trust for yourself? These days, it's a lot easier to do the foundation of your revocable trust because the exemption amount is so high these days. You retire. You get a new house. You got to make sure that when you buy that new house, it's in the name of the trust. And if it's not here in California, it's someplace else, make sure it's done that way. And I don't do too many deeds outside of California, but basically we might want to find an escrow company that's in another state or another lawyer in another state to basically make sure title is properly done. I don't mind for the most part recording a deed anywhere in California. I'm okay with that, but it's we got to deal with Texas and we got to deal with Arizona's, and we have a lot of clients moving to Florida too. So it's one of those things you got to make sure it's in the name of the trust. So here's the one: aging, incapacity. What are we going to do? And you got to be proactive, because if you don't do anything, on the front of my workbook, it says how to avoid probate and a conservatorship. That's a legal process in California. So I will say it gets a little confusing. When you're under 18 and you somehow inherit assets or a parent dies, it's called a guardianship. So under 18 in California, it's called a guardianship. Post 18, it's called a conservatorship. And by the way, if you happen to have minors, you need to have in your wills a nomination who steps in for your minor children. Because if you don't put it down, the courts have to decide or the family fights over it. But if you put it down, that's probably a better choice. So we really want to avoid going to court altogether. And this is where you do an estate plan with a trust and a will and a financial power of attorney, such you avoid this, and there's no need to go to court to get a conservatorship at that point. So over 18 in California, we call it a conservatorship. So you must avoid it. Really, no one likes it. It doesn't help you. It doesn't really help anybody. I mean, look at Britney Spears. There'll probably be a couple books on that. We're going to talk about it. There was a big fight, and the laws just changed to not do what happened to her. It would have never happened in San Diego. So what happened in LA and her conservatorship was kind of unusual. I said because they kind of railroad her into getting what happened there. Okay, so let's talk about planning for incapacity. Inside my workbook, we deal with a couple of documents that deal with health care. One is the post form. Physician order for life-saving treatment. Every state has a different version of it. I see the most medical something orders. Once again, I think my younger clients don't necessarily need to do this. I do a healthcare power attorney. I can customize that for my clients' needs. How do you customize this? You check the boxes. You don't see me to witness this. You need to have your doctor or your PA or your nurse practitioner to sign off on this. And basically, if they find the box that seem appropriate for you, I think, once again, for my older clients, it makes a lot more sense. My younger clients, maybe not as necessary. I'd rather do it through the Advanced Healthcare Directive. But since the law says this is available, I want you to be educated and know what that is. So you put down your wishes. I prefer a healthcare power attorney where someone stands in your shoes to act for your body needs. What happens if you're on life-sustaining treatment and there's no chance of recovery, and the only reason why you're alive is because of machines? You're saying, don't keep me alive, if that's your wishes. Now, I will say most of my clients tend to want that. But every so often says, no, keep me alive as long as possible. So it doesn't happen very often. There's something else, and I want to be clear about this. People talk about the DNRs. And they say, I got a DNR. No, you don't. DNRs are issued out by doctors when you're at the hospital. If that makes sense to pull the plug, you're going to get a temporary DNR for that time you're there. If you recover, you come back, that DNR goes away. So this is more of a doctor's document that you may have ultimately. Your advanced healthcare agent can actually cooperate with this and talk to the people on your behalf, share your wishes at that point. So that was for healthcare. This is some ideas for your finances. You can have joint ownership. You can have a durable financial power of attorney, or my preferred choice is living trust. I got a little problem with joint tenancy. Sometimes the banks, sorry, John, say, I want to open an account, add my son as a signer. It's, make it joint. Well, joint means with right of survivorship, that means that person gets it. You got 4 other kids with money, that means that one kid gets it. That's not what the client really wanted. So you got to get your goals and objectives clear. If you want them to be a signer, the banks usually have a simple power of attorney form themselves. They like their form better anyway. And so, if you want someone to be able to sign on your behalf, you can do a power of attorney. Now, power of attorneys are only good while you're alive. I can't tell you how many times I said, well, I can use the power of attorney after mom dies or death. No, it's only operative while you're alive at that point. So we're going to talk about I'm going to talk about POD accounts, paid on death. We'll talk about that in a second. But basically, the power of attorney stops. So how do you avoid a procedure? You can have that joint account or the account not as joint ownership, but a signer be yourself or for your parents, and then do POD to the 4 kids or 3 kids or whatever kids there are, or the living trust is what I like a lot. A financial power of attorney, I do a very comprehensive power of attorney. Mine's about 10, 12 pages long. It's about 44 powers. It's a very general, broad power of attorney. I don't like the statutory 3-page one. I can't do all the things I want to do. In my power of attorney, I do a creation of trust, gift giving, all these things that the regular power of attorneys are not allowed you to do these things unless they're so stated, which are not usually so stated. So you really want to spell out what are the agents. Can I buy real estate through my power of attorney? You can do that. Sometimes we've done that where a client actually was abroad and the wife or the husband was still here, and we had a power of attorney for the other one, and they'd be able to act and buy a piece of real estate at that point. And you have to record the power of attorney or whatever you're going to do. But basically, it's a document that whoever steps into your shoes needs to act for your best interest in this case. What I like better is that the power of attorney only works while you're alive, but what I like about the trust, and we'll talk about more details about this, is that you get to do it yourself. You manage your own affairs. If you become incapacitated, somebody else steps in. You avoid the conservatorship and you avoid the probate. And that's the kind of win-win situation. So power attorneys, they help you during lifetime. Now, not all assets go in the trust. The retirement dollars. Retirement dollars, are outside the trust, and basically the power attorney will allow us to talk to the person who holds the custodian of the IRA to pull money out for your various needs. So you need to have a power attorney for your retirement dollars and maybe for your annuities as well. Okay, you become incapacitated. Oh, I'm sorry. Yes.
Previous slide.
Yeah.
So successor trustee only happens when we pass away.
Not necessarily. You can die, resign, or become incapacitated. And we're going to talk about that. So hold your questions, and I will definitely talk about that. So I've been to be proactive. I have, just get ahead of the game a little bit. One of the things I like to do is when a husband or wife or parent dies, I like to bring a son or daughter up as a co-trustee. And it's less threatening because people don't like someone stepping in their shoes and have to resign. So if I make them it's less threatening at that point. Okay, so what happens if you need long-term care? We're going to deal with the home. Do you stay at home? Can you be at a skilled nursing facility, boarding care, child's home? My dad actually, about 2 years before he passed away, actually lived with me. I had no problem. Like good lawyers, we fought all day long, but made up during the lifetime as a good son and son was it? That's father's son at that time, excuse me. But basically, that doesn't work for everybody. Does it work for you? I had a very good wife who allowed me to do that. That's not the best option for a lot of people, but be careful on that. Boarding cares you have to look out for. They're actually not too bad, at least cost-wise. When I first started practicing law in 1986, the average cost of a nursing home was $4,000. The average cost of 24/7 care at home, guess what, was half that, $2,000. Today, the cost of taking care of somebody at a skilled nursing facility is $10,000 to $12,000. Guess what it is at home 24/7? Double. It's going to look at $20,000 to $22,000 if you have an HC out there at that point. So it's not, staying at home is not very economical unless you have a huge estate to pay for it. Okay, so what can you do? You could privately pay, and once again, you may have that huge estate. You could pay for it. You may have acquired long-term care insurance. By the way, my wife and I did get long-term care insurance. My wife was very upset. Her father had Parkinson's disease. He said, no, you need to pay for it. So when I was 52, we did a 10-year pay-up policy. It's not even available anymore. So we paid for 10 years, and we stopped paying it when we got past 10 years, and that we have it available. But that's not there anymore. People have it through sometimes work as a school teacher, some government jobs are available. One of the things that maybe makes sense is if you're staying at home and you have this house and you have a lot of equity in it, maybe the better thing is to pull out some equity or do what's called a reverse mortgage. Don't touch it. Just have it there for caregivers to come in just in case. It's there as an option. I'm not saying you should do it. One of the things we look at also for the government assistance. Medi-Cal in California, Medicaid other states. Veterans benefits. Are you entitled, if you're a veteran, will you be eligible for certain benefits? And these rules are constantly changing. As I said, under Medi-Cal this year, how much in assets you need? Unlimited amounts, which was not the case a couple years back. For a single person, it was only $2,000. For a senior, an individual, was actually $35,000. Yeah.
When did that change?
This year, only in California. And also, it allowed, I don't get too political in here, but actually, they expanded not only for legal residents, they did for illegal aliens, what do you want to call it? But basically, it's everybody. You can get Medi-Cal from everybody's perspective. So I think that's pretty generous out here. I don't know what's going to happen there, but the problem is getting somebody into a piece of property or into a skilled nursing facility. It's hard enough as it is. There are not many that are that great that take Medi-Cal. The one that actually I got my uncle into in Escondido, Redwood Terrace, is probably one of my favorite ones out here. And basically, it's not too bad. There's a couple places in Vista and Escondido and all around us here. Not many. They're more south here, actually. But Medi-Cal is really not the better option if you could help it. What happens if you head to probate? So here's the thing. Probate means to prove the will. We're going to talk about how to avoid that. And what Betsy said is absolutely correct. It takes a long time. You have a plan, and basically we'll talk about intestate, but it freezes everything up. And if we get the paperwork, we see a person die, we can't do anything until we get a death certificate, which typically takes 2 or 3 weeks, if not longer these days. We file the paperwork with the court. We don't get a hearing for 3, 4, 5 months sometimes. It's just ridiculous, in my opinion. It's a public record. So here's some of the facts of probate. And once again, let's go to my workbook. And on my workbook, you can kind of guesstimate your estate on page 3. First off, the numbers are based on gross value. Gross value means we add everything up: the house, the car, the stocks and bonds, the furniture, and appliances, get a top dollar value, and we don't subtract for encumbrances, liens, and deeds. So we did do that for federal estate taxes, but for probate, we use the gross value. So interesting enough, if I had if you could find one, I was going to say $600,000 condo, or if I had a $6 million house with can I get a 5.4 point mortgage? The problem is we look at the top value. Still the net value is $600,000 is my point. The thing is we look at the gross value at that point. But what about that will trigger probate? This number changes every few years. Currently, the amount that triggers probate is if you have more than $184,000 below that mark. And basically, if they have a couple $1,000s in the bank or $25,000 in the bank, it's not, or even $100,000, it's not that much of a problem. But if you add your assets, we don't usually count the cars initially. And so if you're below $184,000, there's no formal probate. In California, which I do like, because not all states have this problem, in California, we have what's called a small estate affidavit. So we go to the bank, and there's an account in there in dear old dad's name, and it's only a few $1,000s. The beneficiaries of the will could say it's under the $184,000. There is no formal probate. Now, I like this. It really works well for us in California, but I was doing some lawyers in Texas, I was doing some lawyers in Florida, and actually we just dealt with a lawyer back in Massachusetts. They don't have that. And so really, we're kind of lucky here. It's very, very few times it makes sense to say we're lucky here for tax purposes. Probate takes a long time. I should probably update this because it's not a year. It's probably closer to a year and a half, if not 2 years, for probates. But guess what? It's a public record. I can be in northern Maine. I can go to San Diego Courthouse. I can see who died. And I can go see what you have. I can see who your family is, who your spouse is, who your children are. You see what your assets are. I can see where your creditors are out there. It is an open public record. So this is offensive to a lot of people, and I don't blame them, because that's our system of courts here in California, and the United States, actually. Okay, so let's talk about some basic techniques. So intestate, you do nothing. You die without a will. You have a simple will. Now, I will say, we're going to talk about wills in a second, but I sometimes have clients say, Arthur, I'm going to go to Europe on Saturday. Can we quickly do something? I don't have enough time. So we'll talk about what we can do about that in a second. So you have jointly held property. But the problem that I have with jointly held, I have people say to me, Arthur, well, I want to add my son. I'm going to avoid probate. I'm going to make him a co-owner now. And when I die under joint tenancy, guess what? He gets it. Sure. I know that I'm not the only attorney in here. Most attorneys like to be litigation more oriented. And guess what? If that name of his is on the title and he gets sued, what's going to happen now? They're going to take his half share of that. Well, I mean, that's the problem with it. I don't like exposing my clients to greater exposure. So I'm not a big fan of joint tenancy. I don't mind small cash amounts, but when you put major assets out there, because I will say I have had clients' children die out of order. I've had clients' children die before they did. And what happens to that? It was in joint tenancy. Guess what? It all comes back to mom and dad. Now they die. We're going to have a probate at that point. So it's not my favorite thing to have it jointly held that way. Living trust is my preferred method, but we're going to also talk about contracts in a second. So problems with intestate. If you die without a will, do you have a plan? You do have a plan, but not your personal one. The state of California says we're going to substitute our plan for yours. If you're married, you got community property, it goes to your spouse. If you got separate property, it goes part to your spouse and part to your kids. If you have no spouse, it goes to your kids. You have no kids, it goes to your grandkids. You have no villa, it goes back to your parents. You have no parents, it goes to your siblings. It actually goes up and down a few times. You may escheat to the state of California. The state of California may end up being your beneficiary at that point. So you should have something at the very least. And as I said, you should have something. You should have a simple last will and testament. And I've told clients when they say we talked on the phone, you know, they have a partner. And they're not married to this partner. And I said, well, where do you want your assets to go to? I want to go to my partner. Here's the problem. If you die without anything, guess what? Basically, what happens is it doesn't go to your partner. So have some kind of documentation that says something. And they said, well, we can't see you for a few weeks, or we can't get anything accomplished. Take a piece of paper out. On the piece of paper, you write out what's called your testamentary wishes. On my death, I'd like my estate to go to my partner, my friend, my wife. If she's not alive, go to my son or my daughter or somebody else. And then ultimately, I want you to appoint who should be your executor. And then you sign it. And you don't need to have witnesses in California. And you don't need to have it notarized. And by the way, when I went to law school, you had to have it dated. But the law says you don't need to date it either. But the problem is, if I got two holographic wills out there, which one do I use? The answer is the later one in time, but which one's the later in time? So still go ahead and date them to make sure this is your last will and testament at that point. And then come see an attorney to do the proper estate plan. But that's your Band-Aid. It will be probated, but your wishes will go to whoever you want at that point. It may be a little bit less expensive. You got to make sure you find these documents as well. But we still have the probate with time. We have the costs associated with it. So, joint tenancy. That's another way of holding property. It's, you know, when I first started practicing law, it's interesting. California's been a community property state for a long, long time. And I can't tell you how many realtors would take title as husband and wife as joint tenants. And I'm not quite sure why they did that, other than maybe that's how they did it themselves. And bottom line here is that there's a better way of having joint tenancy. Oh, by the way, we could all be joint tenants together. We can't have community property, but joint, let's go talk about, that's husband and wife's property. So joint tenants to be all together. And as one dies, this others get it. And then ultimately to the last person, when they die, what happens? It goes to probate at that time. So joint tenancy may be the right thing, but in California, we recognize, there are only about 10 or 11 states out of the 50 that do recognize community property. And there's a great tax advantage here. Basically, community property is held by husband and wife. Husband has half, wife has half. But the problem with community property by itself, it doesn't go automatically to the surviving spouse. And a few years back, the law was changed to have community property with right of survivorship. If you have husband and wife, a piece of property, one dies, it goes to the survivor. The problem is when the survivor dies, now what happens? We have probate at that point. And so basically, yeah, people say, I want to wait till the first spouse dies and I'll run over and do a trust at that time. The problem is that it doesn't usually happen that way. So contracts. A lot of us have life insurance. Who's the beneficiary? And it surprises me that sometimes people have documents that don't have a current beneficiary. I've had a number of clients over the years that didn't have any children, so they put down an older aunt or somebody else or a sibling who died beforehand, and they have nobody there. So my general rule is that if you do have a spouse, I recommend the beneficiary under life insurance be the trust. They said, well, I wanted to go to my spouse anyway. You're driving down the street, you get in a car accident, you die, and your wife or husband is incapacitated. Who claims the life insurance? Well, if it's under the trust, the trustee can. We'll talk about trustees in a few minutes at that point. But, maybe the power of attorney. But I think the trust gives you a little more protection as a general. Now you die, and this money comes down to the trust, and you have minors under 18. Well, the trust is going to hold on to it till what age? Whatever you put down. But I said mine tends to be 25 at that point. Pensions. Anybody got a pension out there? They're gone for the most part out there. You got one, great. My wife does too, but it's not many people out there. There used to be quite a few more out there. But does it continue with your spouse? Maybe yes, but when the spouse dies, it goes away. So most pensions don't continue over. I've had a few military clients who had children that were developmentally disabled, and that goes past their lives into their children who are disabled. Retirement dollars, my general rule is I prefer not to have it go to the trust. I prefer spouse first. Why? Spouse can roll it over into another IRA called a rollover IRA, and they just continue to defer it until they die. If there's no spouse, it goes to children. Major changes here since 2020. Prior to 2020, if you inherited an IRA, we get to use your age typically. And what happened was in 2020, we said, no, we're going to let you go roll over to a spouse, but we're going to let you only pull it out over 10 years. And so there's one exception. Well, there's a couple exceptions. One is a disabled child. One is a minor. You can continue deferring it and maybe get a 10-year delay once they turn 18 and maybe extend it out to about 28. So, yeah.
For IRAs or 401ks, if it goes to the trust, wouldn't it just go to the spouse anyway and then roll over?
Well, it's cleaner to go to it depends what the trust says, number one. And it may look past through it. It's cleaner to go to a spouse first because they can roll that into their own separate IRA. Can it be done that way? It's not my recommendation, personally. Have I seen it done? Yes. Have I seen the institutions kind of treat it as being to the spouse? Yes. But you have to be very careful what the trust says. Because the trust, if the spouse is the primary beneficiary, yes. But if they're not the primary beneficiary, you got a problem at that point. Now, I will say, in my IRA, when my son was under 18, my primary beneficiary was my wife. But under age 18, it was my son, I had my trust be the beneficiary. I wanted a control issue versus tax benefits. And so when he got closer to when he got 18, I put him as a backup to my wife as a rule. And then because he has no children, I actually have our trust as a backup to that at that point. So, there's been a little bit of handcuffs on there at that point. I will make one comment. You got to have a beneficiary. I have a client right now, and it's not a huge IRA, and I don't quite, the state, here, you know how you inherit money? You guys are all in the wrong profession. My client just passed away. She just gave her entire estate to a new person she's known for her, not new, but new beneficiary, to her person who does her hair. She gets the house, she gets the $4 million because she has gone to see this lady for the last 40 years of her life, get her twice a week, who does her hair. I'm amazed. I thought become a lawyer, that's the way to do it. But she cuts hair. Anyway, but I don't understand this. The financial guy did not have a beneficiary under the IRA. And by default, it's the estate, and by default, it reverts back to the trust, and she gets it one way or the other. But our hands are a little bit tied as to the trust would have been better than nothing. But having nothing is, I can't tell you how many times this happens, that there's no beneficiary, and there really got to be a beneficiary. Question?
Yeah, so for life insurance, you said it's better to go to trust.
I prefer that, yes.
Why not beneficiary and then secondary?
Okay, so my example is that you're driving down the street and your wife is the primary beneficiary and you get in a car accident and you die and she's in a coma. How do you go claim that life insurance? So it's about the same thing. She's the primary beneficiary, you're absolutely right. But I think it gives you a little bit more protection. Then she dies, it's not in the trust. Because the logic would be she's the beneficiary, you die, she gets the money, and then dies yourself, and did not put in the trust, you got to probate. But if it goes to the trust and she pulls it out because she's a trustee, you're a little bit better off. So look, you talk to lawyers, we're Mr. Doom and Gloom out here. So we got these bad, I'll give you examples. Most of the clients, it's not an issue, but a few it has. It's been great, yeah. That's a good question. Yeah.
What happens if your beneficiary conflict with your trust doesn't work? So like, does one trump over the other one?
So help me out. Sorry, help me out here as to, okay. So basically, your trust says something, and
You have to update your beneficiaries.
Okay. So basically, you change your beneficiaries, you didn't get around to doing it. But you have to use your last document. So to be technical about it, it's sometimes. People don't know this. You could have a trust with assets, and sometimes we do multiple trusts, and you have a will that goes a different direction. They don't always go, the same people. So, I'm trying to figure out exactly, so I clarify your question. We go with your last current trust, and or will, whatever it says at that point. But I will say your beneficiaries may not like what your parents done, and so basically we see, that can cause some problems if it's not what they like, what they're not expecting. That's why I like to share this stuff in advance. Hey, but it's tough when you start favoring one child or another. And then the other kids say, why did this happen? And the kids may not understand why mom did it that way. So that's a good question, because I'll tell you what I do sometimes. I will, so it's clear, I sometimes may get a doctor and get a doctor's opinion whether the person's competent. I may have them talk to more friends. This is why I'm doing it. So I have witnesses now. And I have them clients write me letters and I'll put in the files saying why you're doing this. So you build a case up. You can't do that after the fact, but you can do it in advance and so forth. So it's it can be an issue. Yes. Yeah.
Okay.
Yes, please.
Let's say you have 3 kids.
Yep.
And you have 3 houses.
Yep.
Right now, if I go transfer all the houses, it's already paid to my kids. And I get a power of attorney from them, I operate this property. Could be rental, could be whatsoever. So they have the kids legally under their name, but I get a power of attorney from them that I can run this business for them. So that way, what's wrong with this picture?
Okay. So if I heard you correctly, you have 3 properties and you gave each child a property now.
Yeah, transfer them.
Good. Okay. So a couple things I can see. One is you got reassessed on your property taxes. It's a transfer.
Okay.
So that got reassessed. So whatever you buy for a low amount, and basically it's the higher amount now, number one. Then they turn around and sell it. Either live is a problem because it's your money, or at death, it's already gifted to them. There's no step-on basis. There's going to have capital gains on it. So if you paid $100,000 for it and it's not worth $300,000, you have $200,000 appreciation. Guess what? Capital gains now at that point when they sell it. So you avoided probate, but you just created basically $75,000 worth of capital gain taxes. So thank you very much. You got this gift in advance, but you're going to pay the taxes because I'm not paying it because it's yours. And since you owned it, not me, when I died, there's no tax benefit with a step-on basis. So you want to pass assets that are highly appreciated at death. Don't get around it and try to do it. You really want to have it at death versus. That's a great thing we do. Yeah, go ahead. They get sued. They also, once again, they get sued for this is your asset. They're the owner. They get sued because they have a judgment against your property, but it's in their name. Yeah. I understand. I've heard it before, but once again, it creates more problems. If you get around it, you're creating a lot more problems than you realize. You'll never know because at your death, you really want to pass things to death. You had problems for a long, long time. Yeah, Fred, you might. You're supposed to do that, technically speaking, but if your estate's below that amount, it's kind of almost like a no farm. I'm a big fan of doing that personally. Yeah. Question over here.
You keep saying children. Do stepchildren are included in that? Like, I'm married, I have a stepchild, we don't have any children together.
Yeah.
Say my husband passes before me and I have the trust or the property. Would that apply to my stepdaughter?
Okay. Here's the first off.
And I have a second part.
Depending on, okay, thank you. Depending on the number of fact patterns out there. First off, if you have no documentation, your husband dies, and if it's community property, it goes to you. If it's separate property, part will go to you and his own children, not the stepchildren at that point.
What do you mean?
Okay, so.
Because he has children, we don't have children together.
Yeah, but okay. So on an example, so basically he dies, it's on a separate property, part will go to you, part will go to the children down there. That's not a stepchild. Reverse that. Okay, so basically, do you have children yourself?
No.
Okay, so what would happen was basically your community property would go to him, but if he dies before you, it doesn't go to stepchildren because they're not your children. They're step.
Okay.
But my question to you is, do you want it to go to his children?
Well, you're not half wrong.
Yeah.
There is one child that I would like to see.
Sure. And you could do that. I would say if another client, basically she had two children. This one client who I just talked about actually, wanted to go to one of the two. So it's up to you how you want it. But if it goes to him, but he dies before you, and depending what your wishes are, you got to have it in writing. If you have it in no writing, it goes to...
So my husband passes, I have the house, I pass, and I leave it to my stepdaughter. Is she qualified for that tax? Fred might be able to help that.
Which tax are we talking about? Okay, when you die, first of all, when you're...
She can avoid the...
Like,
Yeah.
Okay, so when you pass assets at death, and what you did, so your husband died, it went to you, you have it now, and then you die, there's a step up in basis at that point. Yes. But what happens is there's another tax. So if we talk about taxes, it's kind of a generic term because we have sales taxes, property taxes, we have real property taxes, we have capital gain taxes, we have death taxes. So the question maybe is if you want this house to go to that stepdaughter, that one person, in California, depending on what the number is, under California law post 2019, basically she would have to move into that house within 1 year of your death.
But so being that she's my stepdaughter, not my biological.
Under that rule, actually, under the assessor's office, I believe they would allow you to have that under that case. But as to inherit it, without documentation, probably not. So that's why you need to put something in writing. I mean, if you don't have anything, put this simple will right now in your handwriting. I decide to go to my husband. If he's not alive, then to that one child. It shows 10/20/10 on my death. Yes. Okay. This is not uncommon to have stepchildren out there, and it confuses things out there. It makes things more complicated and so forth. And it's not uncommon that I have clients that have no children, but one spouse does that at that point. Yeah, it's interesting. If you don't have the right documentation, it goes down different rabbit holes. What if this, what if that, whatever. And it's amazing how you get different outcomes. And yet, all you really wanted to go is go to the husband first, if not, then to the one child. That's your choice. Assuming his too, but yeah. Okay, so one of the things you may want to do is what's called POD. POD stands for paid on death. You go to the bank, you go to U.S. Bank right now, I want this to pass at my death automatically. And in law school, when I took my estate planning class, this is what we used to call the poor man's will substitute. You put down what you want. I don't like large sums of money going this way, but I don't mind a few $1,000s or $20,000 or whatever. Smaller amounts this way. At your death, boom. It goes to the beneficiaries, his kids, and it's in joint tenancy. I guess what? It goes to you, not them. You want to be a signer? Go get the POA. Get the power of attorney at the bank. You can sign, and then do POD. We have a living trust. Let's let it go to the trust. You can sign on his behalf at this point and pull money out and pay whatever you feel appropriate at that point. TOD is transfer on death. You can do securities. You can do a car. Hate to say this to you, you can also do real estate, but stay away from that. Don't do a piece of real estate in TOD. There's a lot of problems. There's actually an encumbrance problem, John, on TODs. They could challenge up to 3 years, so you can't get clean title sometimes. It's not a cheap way out. It really causes more problems. But on securities, sometimes I have a client who has a minor amount of assets out there, and we don't need to do a separate trust. I said, yeah, sure. You want to go to your spouse? You want to go to your kids? Say TOD, transfer debt to his kids or her kids. It's not a bad way of going sometimes. I want to leave a small amount of assets to my caretaker or my maid or whatever you want to do. Maybe that's not a bad way of going. A car. Cars are registered at two people's names, and one spouse dies, one parent dies. You can do TOD to one child. You have 3 cars, TOD to one child, another child, another child. Very simple at death. So it's not a bad way of going if you know where your car is supposed to go. But I don't put cars in the trust typically. The car you have today is probably not going to be the same car, when you pass away at that point. Okay, so let's talk about some trust strategies. What is a trust? A living trust is a legal arrangement which allows you to maintain control of your own assets during life and pass your assets to your intended beneficiaries, not whoever you want. I mean, your beneficiaries, without court, without probate. So, most There's revocable trusts, there are irrevocable trusts. What's the word revocable mean? You can alter it, change it, amend it, modify it, take it back all you want. And guess what about irrevocable? You can't do those things. Except for lawyers have ways of making changes that says you can't do it, but you can do it. That's another story in itself. But yeah, so yeah, most when you do this for whatever reason, for larger estates, and we'll talk about some things out here. So basically, let's talk about the parties involved in a living trust. Basically, I use the word settlor. Some lawyers use the word trustor, and occasionally I see the word grantor. You're the creator. You're the maker. It's your document. You are the trustee. You are your own manager of your assets typically. You are the life beneficiary. What's that mean? You get the benefits during lifetime. We have the assets. We put in the trust. We have a trustee, a fiduciary. Basically, there'll be what's called a successor trustee. Someone steps in at what time period? We plan for death. We could back it up a little bit. We could plan for incapacity, and you can resign. And so basically, how do you prove these things? Well, if you die, we got a death certificate. If you resign, we got a simple note. I resign as being trustee, and we got a notarized. It's very simple. You become incapacitated. That's a little problem, actually. Some lawyers do 2, doctors, I use 1, but I do notarized ones. You have to go back to your doctor and basically have them determine whether you have enough capacity, and most of them will say they cannot handle your financial or affairs, and so the next trustee steps in. And hopefully you're in agreement with it. If not, then you can go to court and let the judge decide whether you have capacity or not at that time. There's some new laws coming into play, I think last year, that basically if you become incapacitated, the next trustee steps in and there's no way to revoke it, you have to give beneficiaries during your lifetime now. So it's a brand new law. And then ultimately it passes to your remainder beneficiaries.